Good afternoon. Welcome to DAKSH's event where we are releasing our new book. It is my pleasure to introduce Justice R.V. Raveendran, who is our guest today and has been a big supporter of DAKSH over the years. Justice R.V. Raveendran is a retired judge of the Supreme Court of India. Prior to that, he was Chief Justice of the High Court of Madhya Pradesh. He became a judge in the Karnataka High Court before he went on to become the Chief Justice of the Madhya Pradesh High Court. Justice Raveendran has earlier helped DAKSH in many other events, particularly the Project Jana, where we have where we did many videos explaining the pathways to justice in India. So we are grateful to have him with us again. I request Justice Raveendran to kindly release our report, which is titled Justice Frustrated. Sir, welcome to the event, and can I request you to release the book?
Thank you. Thank you, Harish. May I take the pleasure of releasing Justice Frustrated, the systemic impact of delays in Indian court, the third in the series of Rule of Law project, edited by Shruti Vidyasagar, Shruti Nayak, and Harish. It gives me a great pleasure once again.
Thank you, sir. Thank you, sir.
Yeah, thank you.
Yes. So can I request Justice Raveendran to say a few words and then we'll proceed?
Good evening, everyone. This is a happy occasion when the third book in the Rule of Law project is being released. When I glanced through the book, two things stuck in my mind. The first was Harish comparing the position of litigants in India to that of Trishanku, a very, very good comparison, I would say, having regard to the unfortunate lot of anybody who happens to be a litigant in India. The second thing that struck me about the book, impressed me, was the saying with which Naganand starts his article based on a Kannada proverb. You are all aware of it. It is Geddavanu Sota, Sotavanu Satta. That is, a winning litigant is really a losing litigant, and a losing litigant is already a dead litigant. Now, these two comparisons, one given by Harish and other by Naganand, very aptly capture the position of a litigant, particularly having regard to the delays in court. Let me give some statistics. The statistics I have culled out from the book I have just now released and also from other sources. Quickly, I will go through them. Judiciary, Indian judiciary presently has a sanctioned strength of 35 Supreme Court judges, 1,080 High Court judges, and 22,700 lower court judges for a population of 1,340 or more millions. This provides a judge population ratio of 18 judges per million. This, if you compare it with developed countries where they have 50 to 110 judges per million, we have only a sanctioned strength of 18. As the sanctioned strength is seldom reached, the judiciary normally operates with a working strength of around 75%, which means that we really have a ratio of 12 judges per million. Now, the total number of cases that are pending in Indian courts is 33 million, 29 million in the trial courts, 4 million in the state high courts, and 60,000 cases before the Supreme Court. As the operating strength of the judges total number of judges is 18,000. This means a average case load of say 1,800 to 2,000 cases per judge, which is considered to be very high. Now, at present, out of the 29 million cases pending in the courts, trial courts, only 8.5 million cases are civil cases, and remaining 20.5 million cases are criminal cases. Now, 80% of the civil cases go to trial, and hardly 20% of the cases get settled at pre-trial stage. Please, in comparison, see in United States, where in spite of judge population being 4 to 5 times or even 6 times more than India, hardly 10% of the cases go to trial and 90% of the cases get settled at pre-trial stage. Now, as this is the position in regard to civil cases. If you come to criminal cases, there is no question of a settlement. Everything goes for a trial, unless a very few cases which get compounded. Let us forget them. Therefore, most of the cases are tried in court. That's why the delay and long delay. Now, most of the cases, civil or criminal, take an average of anywhere between 4 to 5 years for disposal. Now, in some state and in some category of cases, maybe the pendency for a civil case can be as much as 2 decades and 1 decade for criminal cases. I particularly know of some states where, because of the huge backlog, a criminal appeal takes 20 years. A civil appeal or criminal appeal takes 20 years or more to be heard, particularly Uttar Pradesh, Maharashtra, and Bihar. Now, the overloaded judicial system has to struggle with huge pendency, insufficient manpower, and elaborate procedural laws. A powerful bar and a very conservative judiciary have developed a mindset tuned to think of life cycles of cases in terms of years and decades rather than days and months. Negotiated settlements and adoption of alternative dispute resolution processes are not given the push and encouragement which they deserve. The response of the executive to the demands for more judges, more courts, and better infrastructure has been lukewarm. The response of the legislature to the demand for better laws has been sluggish. The response of judiciary for demands for better processes of selection of judges and their training has been unsatisfactory. All these have created delay, resulting in frustration and discontent. In commercial litigation, delay destroys businesses. In family disputes, delay destroys peace, harmony, and health, turning litigants into nervous wrecks. In most criminal cases, the harassment, the humiliation, or trauma undergone by an accused during the long drawn prosecution is many a time more than the ultimate punishment that is handed out to him. This means that particularly those accused who are ultimately acquitted as not being guilty, which constitutes more than 50% of those prosecuted, are subjected to a tortuous, long-drawn criminal prosecution. Irrespective of whether the accused suffers a punishment or not, the complainants also suffer a punishment because they are also not spared of the harassment, frustration, humiliation, and trauma during the long-drawn judicial process in criminal cases. The delays, when considered with other factors associated with litigation, particularly the inflexibility in decisions, technicalities in laws, high cost of litigation, make the litigant feel that justice has become elusive and also elusive. Consequently, the confidence in the justice delivery system and rule of law is getting steadily eroded. As a result, people with grievances, causes, complaints start thinking of solutions outside the legal framework. Incidents of landlords engaging the services of muzzlemen to evict tenants is quite common. Incidents of creditors and financial institutions engaging collection agencies, dubious collection agencies, for collection by applying force is alarmingly has been increasing. There are more and more incidents of powerful politicians, police, unscrupulous police officers, members of the underworld, interfering with and settling property disputes, and in that process grabbing the property or a large chunk of the properties for themselves. This kind of thing cannot continue. But though well aware that these extrajudicial recourses are illegal and risky, more and more persons are persuading themselves to believe that that recourse is the only way to get swift, decisive, and effective result. In this process, law-abiding citizens are becoming a society of lawbreakers. This is the most dangerous side effect of delay. The injustice caused both to complainants as well as victims, as also the persons accused of crimes on account of delay in deciding criminal cases, is mind-boggling. When there is delay, witnesses forget, witnesses die, witnesses are bought, witnesses turn hostile, and the evidence disappears. The investigating officers are transferred, retire, or become unavailable. The victims and their families are threatened or persuaded to give up or face ruination. The public forget and forgive. The prosecutors and judges get tired and exhausted. The result is that India has one of the highest rate of acquittals. The high rate of acquittals demoralizes the victims, demoralizes the police, and demoralizes the law-abiding citizens. At the same time, the offenders are emboldened to continue their life of crime. Rule of law becomes a mockery. The position is no better on the other side. Not all accused are guilty. Please remember, in India, lot of innocents are prosecuted. It is common for persons being accused of crime on the basis of slipshod investigation, false accusations, and political local rivalry and vendetta or framing. Though a person accused of a crime is deemed innocent till proved guilty in a court of law, an arrest or being charged with an offense takes away his freedom and livelihood, apart from destroying his reputation. His family members are shunned, becoming outcasts overnight. At any given point of time, you should remember there are 3 lakhs under trials, persons, that is, persons who are held in custody awaiting trial, locked up in prisons, making about 2/3 of the prison population. More than 3,000 under trial are rotting in jails for more than 5 years. There are nearly 2,000 children behind bars as their mothers are under trial prisoners. At least 50% of these under trials in prisons will ultimately be acquitted on completion of trial. When an under trial who is behind bars for several years is ultimately acquitted, he or she has no remedy for the loss of the precious years of life, freedom, and reputation lost by him or her. Similar is the position of those who are convicted of crimes and languishing in jails during the pendency of the appeals and who may ultimately be acquitted. I am mentioning all this to say how the delay is destroying the very structure of the democratic society. The impact of delay is considered on society. Impact of delay is considered on the litigant. Impact of the delay is discussed with reference to economy, commerce, particularly foreign investment. People say foreign investors are very, very hesitant to come to India because of the delay in Indian courts. And what is not discussed is the impact of delay on the victims of crimes. This is unfortunate, because when do they get justice? And what is justice? We will deal with it a little later. And also persons accused of crime, because this segment is totally lost sight of. You see, a person may be falsely accused of a crime that has been committed, but crime has been committed, but the person accused is not really the guilty party, or a person accused of crime that was never committed, a imaginary claim. It may be under the very harsh laws like Scheduled Caste, Scheduled Tribes Atrocities Act, or even cruelty to wife, etc., etc. It can be anything. Therefore, we are looking at persons accused of crime as a separate segment who are affected by the delay apart from the victims of crime itself. Then many people do not realize the impact of delay on the credibility of judiciary as an institution. People lose faith. I gave the example of how people are going away from courts to other extrajudicial authorities, not authorities, or centers for getting relief, which is very, very dangerous. And the credibility should, once the credibility of the judiciary is affected, the rule of law is itself affected. And many don't consider the impact of delay on the members of the judiciary, which is a very serious thing. When you have, let us say, 500 cases, a judge has 500 cases, he considers, all right, let me deal with each case and do justice. But if you have 2000 cases, it is oppressive. And when it is oppressive, a judge thinks of disposing of cases rather than doing justice. There lies the danger. When a judge starts thinking of cases as statistics rather than a human problem, the real risk is there. The numbers, the oppressive numbers are making judges and the higher judiciary to always think of disposal rather than justice. Now, this is a very serious thing. Now, there are others areas that are affected, but let me not go into it for want of time. But one thing I would like to mention is the delay and justice. When you talk of it, the courts and everyone, even the authors in this book, are considering the disposal of the case, the period of pendency of the case for delay. Let us say a suit is filed today, a suit is decreed after 2 years. They are taking the 2 years as the period of time. If it takes 5 years for a decree to be granted, they consider 5 years. It is not so. See, we are concerned with justice and not a paper decree. This is what is very, very worrying. How long does it really take to a civil litigant to get relief is the question. The question is not how long does it take to get a paper decree. Paper decree may be obtained in 5 years. It may be obtained in 10 years. But does he really get a relief? Now, in fact, I remember the famous saying in Sonawala's book on execution. He starts by saying the real difficulties and problems of a plaintiff starts not when he files a suit, but when he gets a decree. Therefore, when we talk of delay, we should consider the delay not for disposal of the case, but delay for a party to get justice. A civil litigant gets justice when he gets the relief, not when he gets a decree. A criminal court, a criminal justice happens when the person who is accused of the crime, the guilty party, is punished and undergoes the punishment. Not when the matter is before the magistrate court, because there may be appeal, there may be a further appeal, matter may be for 20 years in court and you may be out on bail. Therefore, let us consider, when you consider the impact of justice, impact of delay in justice, the delay you should consider is the delay in actually getting the relief and not when a paper decree is obtained. These are some of the things I wanted to share. The book is a wonderful compilation. You see, there is a well-known saying that if you want a sound solution, then you should clearly identify the problem and you should understand the parameters of the problem. Then only you can have a good solution. Now, that is where this book helps. This book, identifies the problem. This book gives the dimensions of the problem. It also gives some solutions. It is for the stakeholders to now take up the matter and really give solutions to the people of this country. Thank you. Thank you for this opportunity to share a few thoughts in regard to this book. I'm sure that this book and its companion volumes, as also the volumes to be, produced and published in regard to judiciary in future, will help judiciary to become really the pillar of rule of law, which it is supposed to be. Thank you.
Thank you so much, sir. Like you mentioned, sir, I think one of the things that DAKSH was also trying to address is to sort of understand better the impact of judicial delay so that we can find some better solutions to this. So thank you so much, sir. I'd now like to go ahead with presenting the book, and I'm just going to switch to sharing my screen. Just a second. Right. So before we go on to specifically address the chapters in the book itself, we wanted to give you a bit of background into what led us to think about conceptualizing this book and what motivated us to study this topic in some more detail. As many of you may be aware, this is DAKSH's third publication with regard to judicial delays. Our first volume was published in 2016 and was called State of the Indian Judiciary. This book was one of its kind, and it was breaking new grounds in India in that it was the first to understand the problem of judicial delay with the help of data and with the help of analyzing the data regarding the judiciary. And in that sense, was sort of looking to pursue a new approach to understanding the problem of judicial delay. One of the chapters in the book also introduced DAKSH's database, which is a unique database, which is one of the largest currently publicly available databases in India, which contains over 3 crore case-related information and over 41 crore data points of hearings in subordinate courts across the country. The book also sought to produce the results of our first ever Access to Justice survey, which was conducted in 2016, which sought to understand the perceptions and experiences of over 9,000 litigants in subordinate courts across the country. The Access to Justice survey helped open our eyes to a lot of problems that litigants face with respect to having cases in the courts. One of the most interesting findings of the book was also with respect to the costs that litigants face in approaching the judiciary. The survey was an eye-opener for us in also understanding the costs to the economy itself. One of the findings that we found was actually that the loss of productivity due to people going to attend court hearings and losing out on wages or business during that time comes up to an approximate of 0.5% of the Indian GDP. The survey also helped us understand other experiences that litigants have with approaching the courts, and which sort of led us to question maybe not everyone with a dispute is approaching the judiciary to resolve their dispute. So then that led us to think more about the problems of judicial delay and maybe what other means are people using to resolve their disputes. So that led DAKSH to exploring the concept of access to justice itself and led to the publication of our second volume, which was titled Approaches to Justice in India. This volume was published in 2017 and sought to understand the concept of justice from a more holistic perspective, to understand what people do when they have a dispute, their their approaches, whether they go to court, whether they choose to resolve their disputes outside of court, what their experiences have been. So we sought to look at justice from a more holistic perspective. The second volume also had the findings from our Access to Justice Survey 2017, which was a household survey of over 45,000 people from across India. What we sought to do in that survey was to understand, when people have a justiciable dispute, where do they go to resolve their dispute? Why do they choose to resolve their dispute in that means? And to also understand what their experiences were. So what we sought to do was to understand how many people approach the courts and how many people approach non-judicial forums to resolve their disputes. This survey helped us understand a lot of the problems that people face in approaching the courts, and also why people choose not to go to courts. When we asked people during the survey as to what problems they faced due to approaching the courts, 28% of the respondents said that they faced threats and pressure. 27% of them also said that they faced physical and mental stress, and 7% said that they even faced social ostracization. That was honestly something that we were very surprised to hear about, and it's something that made us think more about what are the effects and what is the impact of judicial delay on people. When we asked people who chose, on the other hand, to not go to courts, to go to non-judicial forums for dispute resolution, we found that the reason that a lot of people choose not to go to courts, and 27% of them had said that the cost of litigation is too high. And on the same hand, 17% of them said that cases take too long to be resolved in the judiciary. So while we could understand that these were some of the main impacts, the immediate impact that a lot of people face, which is time and cost, what we also wanted to understand as DAKSH is to go beyond that conception and to see what other impact does judicial delay have on individuals, on society, and the justice system itself. So that brings us to the present volume before us, our third volume, Justice Frustrated: The Systemic Impact of Delays in Indian Courts. And what we have seen when we were conceptualizing this book is that the dominant discourse currently on understanding the problem of judicial delay involves studying the problem through either the lens of procedural irregularities, which looks to understand what stands in the way of a speedy or an effective trial, or it looks at the problem through either a perceived lack of an adequate number of judges. But by doing this, what we realize is that we tend to view the problem of judicial delay as one that's of the judiciary alone. And we don't tend to look at it in the broader sense of how it impacts everyone in society. And it's not just about litigants and the court. So therefore, at DAKSH, we felt that we have to go beyond this. And we wanted to go beyond understanding the cost and times to also getting a more nuanced and a better understanding of what is the impact of judicial delay. So what the current book, Justice Frustrated, looks to do is to examine the effects on various types of individuals, various kinds of litigants who approach the court. What is the impact of judicial delay depending on the various types of disputes that people have, whether it's land acquisition litigation, whether it's labor litigation, arbitration litigation, and also to understand further and new approaches to understanding the problem of judicial delays and new solutions that we can think of to help mitigate some of the impact of judicial delay. Also, keeping in line with DAKSH's emphasis on using a data-driven approach to understanding the problems while also giving it the background that it needs, this volume also has people looking at the chapters look at data analysis to draw some more understanding of the impact of judicial delay itself. I'll now hand it over to Shruti, who will take us through the chapters and give us some more insight into what each of the chapters deal with.
Thank you, Shruti. Thank you for introducing the audience to DAKSH's latest volume, and also to introducing everyone to our past work that has been already published in the 2 previous volumes. Before I go ahead and talk about, or summarize the chapters that we've included in this volume, I want to take this opportunity to thank all the authors who came forward in our call out for papers and responded and sent us their contributions. They worked with us for several months in putting together this volume, and I really want to thank them. for their excellent contributions. Thank you also, Shruti, for explaining our thought process and the evolution of our thought process in how, why we thought the impact of judicial delay and delays in Indian courts, why we thought that commissioning this volume is very important. When we look at the ripple effects of delays, the first cohort, the first most important people that we need to look at are, of course, the litigants. So let's look at what happens and what the experience of litigants has been. I think Justice Raveendran has pointed out to the to the quite evocative way in which Harish Narsappa deals with or characterizes the state of litigants. Right? He called it Trishanku Loka, which is, according to Indian mythology, a state of essentially suspended animation, where you can neither move forward nor can you move backward. You are surrounded by uncertainty, ambiguity, and this colors all your activities. This colors all your decisions. But you have to go on. You have to, because life around you is going on. It's probably not out of place to say that, to a certain extent, given the COVID-19 pandemic, given the sort of limbo that we all find ourselves in, this resonates with us a little bit. But imagine the plight of litigants for whom this is not a 6-month issue, or even a year or two. This could go on for decades. The statistics pointed out by Justice Raveendran, and as we pointed out in our earlier volumes, and even in this book, are show that this is by no means a short-term state. So in Harish's chapter, what he does is takes essentially four cases, and regardless of whether you're a minor victim of a crime such as sexual assault, whether you're a school teacher who's been sacked, or a government engineer whose integrity is being questioned, or even a property owner who's had to fight several decades of battle in the civil courts about your property. Essentially, it's the state of ambiguity and ultimately injustice that you find yourself in, because the system is forcing you to endure the system without giving you a resolution. And litigant experience is something that Amulya Ashwathappa also deals with in her chapter. She looks at it in a with a narrower focus. She focuses on the courts in Faridabad, and she looks at how she's interviewed a few litigants, a small sample of them, and she reports the findings from the survey that she did. She also looks at how there is paucity of basic infrastructure in courts, so that obviously has an impact on litigant experience. And more than just physical infrastructure, it's also the inscrutability of case rostering or case listing. What is the system to this? How much information do litigants have about this? How much control or agency do they have on this? It's all quite opaque. She also touches upon the culture of adjournments, which many authors have talked about, and for this she also reviews a book by Mr. Arun Shourie, and looks at this and says that the culture of adjournment seems to be some sort of an unsolvable bane in our judicial system, and this culture of adjournments has not escaped judges themselves, as Justice Raveendran also pointed out when he spoke. It's something that impacts judges themselves, and Justice Nambiar in his chapter talks about how, as frustrating as it is for litigants to deal with what seem like endless adjournments, it's equally painful and annoying, as he calls it, for judges themselves, because they are ready to adjudicate in a matter, and suddenly they find that they can't do so for whatever reason. So it's equally frustrating for all stakeholders in the system. We're talking about litigants in general, but let's look at the vulnerable sections of society. So when we're talking about these problems, for sections of society that are disadvantaged in many ways, this problem gets compounded for them. One of the most obvious sections of societies, and again, this is something that other authors have talked about, is the plight of the undertrial prisoners. Mr. Vijayaraghavan, in his chapter, based on his very wide and several decades of experience working with with Undertrial Prisoners, he draws upon this experience and he gives us he describes in quite detail the trauma that they go through because as under trials they face social ostracism, they face isolation, they're excluded from society. And again, as Justice Raveendran has already pointed out, there are many women who suffer even more acutely because of being under trial prisoners, and whose children, because until the age of 6, children aren't allowed to go out and they have to stay with their mothers. So he highlights this problem as well. What his chapter does is, essentially demonstrates a clear correlation between marginalized groups in prison, and the more marginalized, the more socially or economically disadvantaged, the greater their distress. And what happens if there's economic backwardness and poverty, but there's also prejudice. And Arpita Biswas in her paper deals with the transgender and intersex population in India, and she says that there's already deep prejudice against them, and in this situation, when they are confronted with either whether they're accused of crime or whether they're victims of crime, the society, the problems they face are compounded. They're essentially invisibilized. That's what she says, because they're neither seen nor heard. They're not even acknowledged as members of society who have rights and whose rights need to be enforced. And when it comes to the judiciary, based on her study shows that people from this community face judicial indifference and also face a lot of structural and administrative difficulties. There's another chapter that deals with vulnerable sections of society, and this is by John Richard Ebenezer, Tina Kuriakose, and Ruth Thomas. They discuss the difficulties that are faced by survivors of human trafficking, whether it's because they were exploited for sex work or whether they were exploited as bonded labor. And they find that because of the obesity of the system, because of their lack of knowledge, because of the essentially the lack of help as victims, they find that the process is so complex, the costs, the time, the delays all make them lose their faith in the justice system, in the public justice system. And this again is one of the things that is very starkly is a stark reminder to us of beyond litigants, what is the systemic impact. And when we're talking about litigants, we can't certainly ignore the government, which has been pointed out by several people, that it's the largest litigant in the courts in terms of the number of cases that the government is involved in. We have 2 chapters that deal with how the government can find itself in a bit of a problem in the sense that it's less obvious than it seems. And this is a chapter by Malini Mallikarjun, who writes based on her experience and her work with several education departments in several state governments across the country. And she says that there are often education departments in the litigation, and in trying to streamline them and to streamline their management, she finds that it's a wicked problem which seems insolvable, but can be solved with the aid of technology. But what is most worrying about one of her findings is that being involved in litigation has disrupted their normal work to such an extent that people who inhabit these departments are finding that litigation management is taking over their normal duties. They're unable to oversee their regular or discharge their regular functions. So this is truly a worrying impact. And when again talking about the government as a litigant, there is some measure for reform, some hope in the chapter that Mr. Ajay Gupta has contributed to this volume. And he talks about how the central government, in order to streamline its litigation management and ensure that there are no delays in the sense of the government's response to various cases, what they've done is devised a system called LIMS. And what this system does is it identifies, tracks, and responds to cases that involve all central ministries, departments, related departments, and the connected offices. This is a very good development indeed, and we hope that it can be emulated by other state governments as well, so that delays in government litigation, or where the government is a party, can be mitigated to a large extent. Now let's look at the economic consequences. Again, one of the more obvious sort of categories where we can examine the impact of delay. And it's inevitable that we have to consider the economic impact. The World Bank's ease of doing business is just but one measure, right? The rankings are just one measure of how the work of courts can impact the robustness or the perception of robustness of a nation's economy. It's more important for us to look at how economic outcomes of firms and industry that have to work in this environment, how when they're involved in delay, when they're involved in cases that get delayed, how their economic outcomes get impacted. So in this section of contributions, in this section in the volume, we have several interesting contributions. One of them is a chapter by Manaswini Rao, who's an economist, and she does a very meticulous analysis using both public data and private data. And she looks at court performances, right, as indicators of and how they correlate, how they impact economic outcomes. And this is a very interesting analysis, and it's very focused on using data, and makes for very interesting reading. Alok Prasannakumar looks at land acquisition litigation. Again, land, industry, economy, the connection between them couldn't be more obvious. And so Alok, in his chapter, looks at cases from Karnataka, both on the appellate side and on the original side, and he looks at them in terms of their life cycles. He examines whether how these cases perform in terms of how long they take in the courts, how they progress differently based on whether they involve questions of ownership, whether they involve questions of compensation. So his findings and the questions that they raise in terms of how land acquisition cases getting stuck in court essentially is a bottleneck for economic progress, and the questions he raises are very, very apt. Then we have a chapter by two legal counsel, Neha Munjral and Shelly Saluja, who in their chapter talk from an insider's perspective on how, as counsel to large multinational corporation, they advise their employer, or they advise their client on how to manage litigation, and before that, even how to avoid litigation. Right, there are many pitfalls, and so they discuss how they have to ensure that their daily operations don't get affected by the delay or by the extent of litigation that they face, and so the steps that they take, how they do that, and also how they have, they tell us how many of their processes and their operations are essentially changed and geared to ensure that they avoid litigation in the first place. Then we come to the chapter by Shruti Nayak, and she talks about another most important aspect of the economy, the labor force, right? The people power. And she looks at cases both from industrial tribunals and labor courts in Maharashtra, and she finds that in the prescribed timelines for disposal of these cases have breached almost always. Most cases overshoot them, as she says. And in light of this, the impact that it has on both the employer and on employees, who, again, as a result of uncertainty, the impact she discusses the impact that it has on them. It's also we've also looked at how, given how delays are problematic, how and whether there have been any statutory interventions or whether there's been any law that helps in ameliorating or mitigating some of these delays. And there are two chapters that are interesting from this perspective. One is by Aparna Ravi, who looks at the recent amendment, who looks at the fairly recent IBC, Insolvency and Bankruptcy Code, and the recent amendment to the code as well. Again, from the perspective of examining timelines, which are quite strict and quite strictly laid out. And she looks at how that impacts the proceedings of insolvency cases that come before the tribunals. And she essentially examines whether these strict timelines have improved timelines in insolvency proceedings. And she says that it's important to look at this and continue to examine them because any delay has a detrimental impact not only on the underlying assets, but on business and economy and the stakeholders themselves. The other chapter, which is also very interesting, is one by Purnima Hatti, who's talked about how and to what extent courts are expected to, and the role of support that the courts perform in their supporting role in ADR, alternative dispute resolution platforms, right? As Justice Raveendran was saying, there is, given the problems of the judiciary, there is a greater push, there is a greater awareness that alternative dispute resolution mechanisms are and should be used more. But specifically in arbitration cases, specifically in the context of an amendment, again, a recent amendment, she looks at whether the timelines, well, in arbitration cases, there are very limited reasons why you can or you're allowed to go to court. And there are now timelines in terms of how long those applications should be pending. And she says, again, that, when she examines the cases that have gone to the courts with underlying arbitration, she says that these timelines are not being enforced strictly again. And so we're back to the problem of courts even seeming to undermine ADR processes. So this again is quite a worrying finding. Keeping all this in mind, we've now looking at what delays do to democracy, and that's why our focus is also on the systemic impact that it has: democracy, rule of law, and one of the most obvious key factors in a functioning democracy, and one that as Indians we're very proud of, is our elections. And so we have a chapter by Ritvika Sharma and Titiksha Mohanty, who talk about how election petitions, which essentially where one candidate is challenging, the outcome of an election because of malpractices or whatever the reasons are, and how these cases progress, how long these cases take in the system. And again, the findings are startling and unfortunate in that the strict timelines again that have been laid down in the statute about by when these cases should be disposed of are just being overshot. These timelines are not being followed, they're not being complied with. And essentially what is happening is that by the time the decision comes in a court, it's probably rendered infructuous because either most of the term or at least half of the term of the candidate who's hoping to win or who has not won is already over. So it's not a relief by any yardstick, right? So, and this is where Justice Raveendran's point very much on not just the amount of time it takes, but what is the final impact? What is what does it mean in terms of justice? That's where that point becomes very relevant. So, coming to democracy, rule of law, the larger systemic fallout. Mr. Naganand and Sharda Naganand have also talked about it in their chapter, and they talk about how people are resorting now more and more to extra-legal remedies. And we've seen not just people resorting to extra-legal remedies, but the general population celebrating these extra-legal remedies, right? I mean, we don't have to see further than what happened in December of last year when the we can't even call four suspects in a gang rape, in a brutal gang rape in Telangana and Hyderabad. They were encountered by the police, latest encounter of Vikas Dubey. It's not just about the fact that these encounters happen, but the fact that the public is celebrating celebrating them as if this is something that is desired or desirable. And this is a very dangerous trend, and extremely worrying. In the chapter by Naganand, they also point out how the system, the more the delay, it encourages and it breeds corruption, it breeds nepotism, leads to lack of accountability. Harish Narsappa again also deals with it in his chapter where he talks about the convergence of legality and illegality. There is no incentive for following the law, even amongst members of the public who may want to be law-abiding. And ultimately, when we think of all this, I go back to what Justice Nambiar has said in his chapter, and he says, this is a very dangerous trend, and it is very disheartening. It causes great dismay and disquiet. But he reminds us, very importantly, of why we are where we are, and the judiciary is something that has been set up by the Constitution, which we've given to ourselves. So he says the power is with us to change. The power is with us, and it's our collective responsibility to ensure that the system is reformed. And so he calls upon everyone to contribute to this. I know the volume is called Justice Frustrated, but it's not all gloom, and it's not all portentous. The volume does have some chapters on that talk about some measures for reform, looking at data differently, looking at some of the solutions, even examining some of the solutions differently. One of the most interesting findings and interesting chapters is the one that's been authored by Surya Prakash and Siddharth Mandrekar Rao. The most touted, or one of the most often heard solutions to the problem of pendency is it's just a number. Why don't we increase the denominator or increase the numerator, depending on how you want to write the fraction. Just get more judges in, open more courts, and we'll have less pendency. Right? That's been something that has often been advocated. So they take on this and do a very interesting statistical analysis. They look at two courts, newly opened courts in Mysore and Chamarajanagar, and they put this hypothesis to the test. And their findings are very, very interesting in that they find that in the long run, over a period of time, the new courts have not performed as well as they should have, given that they started with whatever number of cases. So this basically, this shows us that the premise of perhaps the solution is not fully thought through, and we need to tackle the more fundamental problems that are associated with pendency before we just advise governments or stakeholders to just start new courts or appoint more judges. Keeping in line with interesting statistical tools that are being used, we have a chapter by Arunav Kaul and Gaurav Banerjee, who give us a very interesting chapter again on how predictive statistical tools can be used to predict caseloads on how you may see case filings going up or increasing over the coming months. And they say that this is a good way to handle caseload. This is a good way to know, to be prepared, so that perhaps even solutions such as maybe for this time we need new courts, maybe for this particular area we need newer judges, perhaps that could be a solution. They also look at how cases get stuck at various stages, and they analyze disposal times on that basis. We also have another chapter by Sridhar Pabisetti and Ritvika Sharma, who want us to take a different new approach to the problem of impact, to the question of impact of judicial delay. And they say we need to look at it from a transaction costs based approach. And they say that, rather than looking at only at outcomes, looking at litigation management, particularly in public law, they analyze several cases that were public interest litigations. And they say that, looking at it from a litigation management, a managerial way of looking at it will probably help us and help us move forward to maybe even re-engineer data management systems that the courts now have, so that we can, or stakeholders can examine better the impact of judicial delay. So that's a summary of all the chapters. And again, I want to thank Justice Raveendran, who who's extremely thorough in his analysis. We've also taken note of some of the aspects that he said were not present at the moment, and that is something that we look forward to working on as we go forward. One of the other suggestions we've had is on looking at the psychological impact of litigation on litigants, and that is something we certainly look forward to doing. Thank you, sir, for releasing the book and for your very insightful and thoughtful comments on the book. And I will now hand over back to Shruti. Thanks.
Thanks so much, Shruti. That draws us to the close of today's events. I'd just like to take the opportunity to again thank Justice Raveendran for taking time out to release this book and join us virtually for this release. We would have loved to have had this event in person, but given the circumstances, I think this is the best that we can do for now. But thank you so much, sir, and for also sharing your experiences and your own reflections on how the impact of judicial delay plays out in everyday life. Thank you so much. We'd also like to thank all the contributors to this volume. It's been a pleasure working with everyone, and it's been a while, but thank you so much for helping us bring this volume to fruition. We'd also like to thank Bloomsbury for all their help and support in publishing this volume and to getting it to the place that it is right now. And we'd like to thank all our viewers today for joining us for the release of the event, for the release of the book. And the book is now available for purchase. You can get a copy on either Bloomsbury's website or on the websites of Amazon and Flipkart. So please do get a copy, and we'd love to hear what you think. So you can write into us at communications@dakshidya.org, and we'd love to know your thoughts on the book. Thank you once again, everyone, for joining us today, and have a great day. Thank you.
Thank you.